Good afternoon. I'm Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We're delighted that you're able to join us virtually today for the next webinar in our virtual webinar series. The Trust is pleased to be able to offer this informative content free of charge to our policyholders. As a Trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of many benefits our insureds receive through the Trust. 3 of our advocates are with us today, Drs. David Shapiro, Jeff Youngren, and Lisa Bryant. While I have a captive audience, I want to take a moment to acknowledge a very special achievement of one of these advocates, Dr. Jeff Youngren. Dr. Youngren was recently presented with the 2022 Distinguished Career Practitioner Award from APA's Division 29 in recognition of the contributions he has made throughout his career to the advancement of psychology. Please join me in wishing him a heartfelt congratulations on this remarkable and well-deserved accomplishments. Congratulations, Jeff. I hope you benefit immensely from our forensic tips for the Practicing Psychologist Roundtable. Please join me in welcoming Drs. Bryant, Shapiro, and Youngren. It's all yours.
Great, thanks, Jana. Welcome. I'm glad to be here with you, Jeff and David, and all of you out there participating. As Jana said, we will get to as many of the live Q&As as possible, so feel free to go ahead and type those in anytime those come up for you. And we're going to start off as we normally do with a couple questions based on the questions we get most often. So Jeff, I will start with you. And as you know, we're focusing today on forensic tips for the average practicing clinician. So can you start us off by discussing what are some of the common role conflicts that occur when treating clinicians are brought into or get involved somehow in the legal system?
Absolutely. It's really, as you know, Lisa and David, a common question we get with the risk management program about what an individual's job is when they start to interface with the legal system. And it's very important to stand back and define what your role is, because the legal system may not do that for you. If you are a treating psychologist, in all likelihood, attorneys are going to want to use you as an expert, but in fact, you are not an expert in the legal sense. You are there to provide what we would call precipient or fact witness kind of testimony. And so transitioning to the job of an expert is not a part of the job of a treating therapist. And it begs the question, of course, of, what is the difference? Well, a fact witness can testify about what they saw, heard, tasted, but whatever they experienced, but they really are not supposed to render an opinion in a legal matter. And you really want to make sure that you carefully define your role through consultation with other individuals, just to make sure that you have your handle on the limitations of what that role is. It's a very valuable role. You are a witness, but to be reductive, you're simply evidence, and and you're not there to provide direction to the legal system.
That's great, Jeff. Thank you. David, anything you want to add to that? Oops, David, I can't hear you. Are you, Jeff, can you hear him, or is it just me?
I can hear you, but David's muted.
Okay.
Yeah, I'm sorry. I muted and I forgot to unmute. Yeah, just to emphasize what Jeff already said, that you have to define your role because the legal system will not do it. I think that's a very important takeaway from what Jeff was saying.
Yeah, I agree. And I like too, Jeff, how you commented that in essence, they're there as evidence, right? Testifying to the facts of treatment, not to opinions about whatever the psycholegal matter might be that's at hand in the legal case.
Yeah, and to decorate it just a little bit further, you don't have to accept assignment from the court. You decide what your role is in that. So if a lawyer wants to make you an expert, You simply should tell a lawyer, I'm not going to accept qualification as an expert, which they may object to because you're not doing the job they want. Their job is different than yours, and limiting your role to being a piece of evidence in the proceeding.
Mm-hmm. Yeah, that's a great point. Thanks for highlighting that. So David, I'm going to move to you then with question number 2,
Sure.
Which is another one we get very commonly. We get calls on this. How should a clinician, so a treating clinician, handle a situation in which they receive a request for information about one of their patients who is involved in some kind of third-party lawsuit unrelated to the treatment? So, it might be a personal injury lawsuit, it might be, a wrongful death lawsuit, but it's not related to the treatment. What are your thoughts on that?
Sure. Well, this is a bit complex because you have two competing issues. One, the issue of legal discovery, and another, the issue of our concerns about confidentiality and privilege. So the first thing, if you get a request and you don't know who this is coming from, first, you neither confirm nor deny that this person is a patient or a client of yours. Make sure that if you're going to do something, you have written authorization from that individual. And if there's no written authorization, then there may be a court order, but you don't just respond in a knee-jerk kind of fashion. Sometimes you want to ask to actually see the legal filings to make sure that the person's mental state is part of the litigation. And because if someone puts their mental state into litigation, it automatically waives privilege. Legally, it's only those matters directly relevant to the litigation, but sometimes you get into debates and disputes in court about what is relevant to the litigation. Beware when an attorney may be going on what we call a fishing expedition. If you don't know that the individual has authorized it, you don't respond at all.
Mm-hmm. Great. Thank you, David. Jeff, any additional thoughts you want to add to that?
Yeah, just really the thing that we make available and we encourage people to do as a part of our program is to engage in consultation to get some of these things answered before you end up in a situation where you're being called upon to testify, release information, or whatever. Most people who are listening are not attorneys and they aren't practicing law. And if you don't know the answer, we can get you the answer. That the risk management program has access to ways to answer those questions. So when I used to teach these workshops, I would always say that when you deal with the legal system, remember the rule number 1, which is if you don't know what to do, don't do anything. There is an answer out there, but you don't know it, and we can get that for you.
Yeah, I think that's great. As we'll probably say many more times tonight, consult, consult, consult. And just to highlight, David, you mentioned most of these, but, certainly I think starting off with not doing, neither confirming nor denying, right? Giving no information at all. I think that's a key point. If the patient, meeting with the patient and talking with the patient, I think this is another piece about what's actually in their record, so that the patient is informed when they have to decide, yes, I'm going to sign an authorization to release, or no, I'm not. I, as a patient, can know what's in my chart, because if we don't let them know what's in the record, they may not be able to make that informed decision. So I think that's a really important point to add. And then if they do, David, as you said, if they do want the release, getting that signed authorization. And also, I think sometimes it's helpful to let the patient know that they can go talk to their attorney about the pros and cons of releasing their whole record into court, as well. And then, of course, if they don't want you to release it, then you assert and or get consultation, Jeff, as you're pointing out. So I think all of those are really good points. Okay, Jeff, coming back to you with our next question. As you know, and sort of have hinted at here already, lawyers commonly want to qualify treating clinicians as experts in forensic matters. And I know you touched on this just a little bit earlier, but if you can sort of explain more concretely why that's problematic, and what clinicians can and should do in order to minimize their risks?
It's a really important point, and I'm glad we raised it again, because the job of a forensic psychologist is simply different than the job of a treating psychologist. The privileges are different, the rules are different, and so it's not simply a small matter if an attorney wants to take you as a treating psychologist and convert your role to that of an expert. And we have a wealth of written literature. Probably the seminal work is Greenberg and Schumann, which is available and we can make available to you, about the role conflicts that occur when you change that role. That treating therapists are advocates. Forensic experts are not advocates. Treating experts get one side of the, treating therapists get one side of the story. Forensic experts are supposed to see both sides of the story. You know, they're supposed to test the null hypothesis that it didn't occur. So the jobs are simply different. And forensic psychology is a trained specialty. So an attorney just saying to you, well, we just want to qualify you as an expert so you can testify about your patient's mental illness and how her PTSD is because of a car accident, that is simply a forensic question. And you really need to establish your role clearly with that attorney, saying you're not going to accept that assignment. And you don't have to accept the assignment. Nobody can make you become an expert.
Yeah, great. Thank you, Jeff. David, anything you want to add?
No, I think that pretty well covers it.
Yeah, I agree. The only thing I'll add is that, you know, Jeff, even when they do that and set that clear role in the beginning, sometimes they still end up in court and the attorneys will ask them those questions anyhow, right? And so that's the perfect time to say something like, I don't have an opinion about that. I didn't do an evaluation to assess that. I have no opinion, that wasn't my role, something like that. So even on the stand, if the attorney continues to push and surprise you, you can reset that boundary really clearly and very appropriately on the stand too.
Yeah, that's a really important point, Lisa, which is that, you know, the legal forum is an adversarial process, and the goal of the attorney is different than your job. And so, again, in our workshops, we have trained people that when you end up in the courtroom, there are two things you must be willing to say. One is the word no, which is a great word, which is, doctor, do you have an opinion about whether Mrs. Johnson should be the custodial parent of her children? The answer is no. Or the better one is, I have no opinion. That's the second one. And really, doctor, you don't have an opinion? Can you make up an opinion? Well, of course not. I mean, that's ludicrous, right? So you don't have an opinion. You have to stay in control of the process. I know it's adversarial, makes some people very uncomfortable, but I think that knowing where the limit is for you and what you are willing to do, don't let the attorney define that for you. You're in charge of your professional credentials.
Yeah, no, that is key, Jeff. And I think sometimes, and this is why we're having this whole webinar today, but it's hard for, you know, a treating clinician who may not have forensic experience to know exactly where those lines are. And so back to both of your points about consulting, this is what we do on the consultation line a lot, you know, and we'll say, like, if, you know, how would you answer this question versus that question? So again, if you're not quite sure where that line is, that's the exact right time to call in and get a consultation. Okay, David, I'm going to move back to you for our last question before we start taking some of the live questions that are coming in. And as Jeff was just mentioning, so you guys are teeing off each other already, which is great. We know, right, clinicians are often asked to weigh in on questions such as custody, visitation, parental fitness, things like that. And usually that happens when they're in some sort of treating provider role, right? They might be providing treatment, individual treatment to the child, or they may be doing individual treatment to the parent or a couples treatment. So can you speak to some of the potential risks when that happens, when the treating clinician is asked to give that sort of ultimate opinion on those issues? And then also, and importantly, what some good risk management strategies would be for that treating clinician to minimize risk in those situations?
Sure. Jeff has mentioned a number of these already, but just to once again emphasize that a psychotherapy relationship, a forensic evaluation, they are two different kinds of relationships. They have different kinds of methodologies associated. And as Jeff mentioned, different kinds of privileged communication issues. And it would really muddy the waters if somebody were to mix the roles. You always have to clarify your role, preferably in writing to both the client and to attorneys, and do this in advance in an informed consent document. And review this. An informed consent document is not set in stone. Review this as the case goes on, and especially if some issue of litigation comes up. Again, re-emphasize what the roles are. As Jeff said, you're going to testify only as a fact witness, not as an expert witness. Sometimes it may be tricky. You're giving what you think is just a clinically based opinion, and you get the trick question. Now, doctor, given what you have stated, would it be a fair statement that these issues would impair their ability to parent? You know, and you say, I don't have, as Jeff said, I don't have an opinion on that. I didn't do that kind of evaluation. I didn't do that kind of work. So always consult with an attorney. That almost goes without saying. So just don't answer any questions regarding any of the legal issues.
Mm-hmm. Great, thank you, David. Jeff, anything to add? Oops, Jeff, now I can't hear you. I'm not sure if that's my end or yours.
No, it's mine. I turned it off for background noise problems. Okay. I apologize, and then I didn't remember to turn it on. So David and I are equal now. But I mean, people frequently when we do calls will say, well, what if the judge orders me to do that? What if the judge orders me to render an opinion? Well, first, that's not going to happen. But even if it did, and there are always rogue judges, right? I mean, you still can formulate your opinion to be non-conclusive and qualify it. You're not going to get in trouble with that anyway. So you've expressed that you don't have an opinion. You've expressed that you don't have a foundation upon which to render that opinion. You've expressed that this is not part of what you did. And if the judge is off the wall and orders you to do it, then I guess you take your best qualified shot, and that's all you can do, right? I mean, that's that will be dealt with in an appellate level or something else, not your issue. But I have to say, I have rarely have ever heard that happening.
Right, I agree. I mean, if a clinician states very clearly in open court, I didn't do an assessment to arrive at that conclusion, I don't have anything to, you know, most judges are not going to keep pushing that at some point, right?
Correct.
So yeah, I think that's a great point. And David, I wanted to circle back to something you said that I think deserves highlighting, which is, you know, you mentioned the informed consent, and then you mentioned reviewing it, because as we all know, right, informed consent isn't just something we do in the beginning. And especially with this, you know, if we start with a client who's not in some sort of legal situation and then 6 months or a year in gets into a legal situation, very important to go back and review this and clarify role and set really clear expectations about what your role is, what it isn't, what you will and won't do vis-a-vis the court. So I think that's a really important point that you made too.
Certainly. Okay.
Great. All right. So we are going to move into your live questions. First of all, Jeff, you're getting lots of congratulations. So we'll add more congratulations on your award. You can read those afterwards. Okay. So here's a question. My client changed insurance companies about 2 years ago. Her current insurance company has requested records. Does the insurance company have a right to clinical records prior to their insuring this client? Meaning, you know, do they have a right to the records before they were an insurance company? Sorry, before that was her insurance company. Jeff, you want to jump in there?
Yeah, I take a shot at it. I mean, it depends upon the authorization that's occurred. I mean, if in fact the authorization that's signed for the current company includes the historical records, this is where people need to read what they're signing and what they're using, then those records usually are discoverable. And the fact is that even if you don't produce that my bet is that the insurance company is going to find some way to get them. So if you say, I'm not turning them over unless, and I actually think this is not a bad idea, it's my idea anyway, but that you say to them, I'm not turning over these records, you need to explain to me how you have a right of access to these records. And so you put the onus on the carrier to prove to you that they in fact do have a right. Your job is to maintain the confidentiality of your client. And I always think that if you can put the onus on somebody else, go ahead and do it.
Mm-hmm. I agree. David, anything to add there?
No, that pretty well covers it.
Mm-hmm. Yeah, and like you say, the only thing I'll add is just, at some point you may need to go back to your patient and explain, here's what they're requesting, and ask the patient if they want the release, even to their own insurance company, like you were getting at, David, Jeff. Okay, so this is a question I think back to, it looks like testimony, and it says, as a treating psychologist, may I answer questions regarding the diagnosis, such as to define and explain PTSD to a jury? David, why don't you jump in on that to start?
Yes, that is fine. You are a fact witness, and that is part of the facts. That's part of what you have done in treatment. You have done an assessment, you've done a treatment plan, you have made a diagnosis. So there's no problem with offering a diagnosis. It's when they try to take it beyond that and say, well, post-traumatic stress disorder, might that not explain this or that kind of behavior in terms of some sort of legal setting? That's where you draw the line. But those are issues within your role as a treating individual, because you do an assessment, a treatment plan, and a diagnosis. So yes, you can offer a diagnosis.
Mm-hmm. Jeff, any additions?
Just to decorate it a little bit, I think it's a clinical diagnosis anyway. It's based upon your responsibility to believe what the patient is telling you is historically accurate, which is entirely different from the forensics job.
Right.
That information may not be historically accurate. So you take that information, you're an advocate for the patient, and you arrive at a clinical diagnosis. But I think it's important for people, when they're asked that question, to make it clear that this is a clinical diagnosis. You have not seen the paperwork on the other side. You don't know whether the incident really did occur. You don't know whether there's memory contamination going on. You're just treating the problem that the patient is bringing and giving them the appropriate diagnosis consistent with that. Whether it's true or not, you don't know.
Yeah, if I may just add to what Jeff said, let's take this example of post-traumatic stress disorder. One of the questions they'll want to know is what caused this post-traumatic stress disorder. You don't know. You haven't done the kind of evaluation to determine it. Was it the current trauma? Was it some sort of childhood trauma? You don't know that. So you don't give an opinion on that.
Right. And I think one of the key things that you're both getting at here is to be really clear, if you're testifying as a treating psychologist, to be clear about the limits of the data on which you're testifying. So to be clear, look, the only data I have, if I'm the treating psychologist, is patient self-report and probably my observations in session. But short of that, very few treating clinicians have outside data. And so, you can say patient reports symptom developed after the motor vehicle accident or whatever it was, but that's different than you, the clinician, saying, yes, the motor vehicle accident caused his or her PTSD. So yeah, really great points there. So yeah, here's a question. I'm gonna, it's good because I think this will give you guys a chance to clarify. The question says, did you really mean, quote, don't respond at all to a subpoena? Don't we, absent consent or court order, need to attempt to have a subpoena quashed or a protective order? So David, you want to start on that? Jeff, I'll let you follow up.
You do need to respond, but you don't have to do what the subpoena is asking you to do. A court order is different. If it's got a judge's signature on it, you do have to follow it. But with a subpoena, you can always file what is called a motion to quash, a motion for a protective order, and then you would specify what it is you can't do and the reasons you can't do it. So you do have to respond to it, but you don't have to produce the data that is being asked for.
Great. Yeah, sorry about that phone ringing in the background.
Sorry about that.
That's okay. Jeff, anything to add to that?
It wasn't my phone. Anyway, I'm listening.
It wasn't mine. No, just teasing you.
Anyway, yeah, I mean, a subpoena, it should be approached like something that's alive. You know, it either has to die or be fulfilled. There's some rules around it. Most people, as I said earlier, are not attorneys anyway. They don't know the mechanics to deal with that. If you have a subpoena, you don't have an authorization, well, we've said this 1,000 times, you can consult with us. We'll help you figure out what to do. But you can engage in a process called quashing, which will be a way that the court actually kills the subpoena. You can retain a counsel for that, usually not a covered benefit, it's part of practice, but that's a procedure. You can do that yourself as well to quash the subpoena, but you can't just stick it in a drawer. And this is something I really want to say to our insureds. We have 700 people listening. Don't wait to find out what to do with the subpoena after you get it. I go crazy when people say, I got my subpoena a week ago and never did a thing with it, and I have to comply tomorrow. Like, I feel like saying, I'm an old guy, I go like, give me a break here, please. I mean, it's been in your drawer for a week. Now we got a problem. It's not an emergency. There's no such thing as a legal emergency. But that the insurance, please, bring us in the game early. We can help you with that. But if you stick it in a drawer and you're like, I'm not going to do anything about it, you really could run into contempt of court charges for that, which could be serious.
Mm-hmm. Yeah, no, that's a great point, Jeff, that, to act quickly, but not to act meaning, get consultation quickly. I think earlier when, I can't remember which one of you, David or Jeff, said that don't act at all. It wasn't that, it was more just don't act immediately. Don't overreact. If you get a request, as I think Jeff said earlier, you want to go back and figure out what are the steps that you should do before you, take an action and release something, right? Because we, to use a phrase Dan Taub, our colleague, says all the time, we can't unring a bell. So once you release those records, you can't take it back. But I think, and just to clarify too, I think your point, Jeff, about not waiting is really important, both for if it's a subpoena, but also if it's just a general request, right? Sometimes we'll get just a request that isn't a subpoena, but we can't ignore those either. Even if a patient says, no, don't do it, we still have to, there may be laws in the state that say we have to give a response at some point within a certain period of time or those kinds of things. So ignoring anything is usually a problem.
Super point, Lisa. I agree. Under HIPAA, you got 30 days, but there's state laws that regulate that as well. And if you don't know what to do, don't do anything. But there's an addition to that statement until you get consultation to know what the right thing to do is. Doing nothing is, of course, not the thing to do. You have to do something, but you don't want to be impulsive. For example, if the attorney that wants the records says, "Oh no, you can send those off to me," that's fine. Well, that attorney can't give you legal advice, and it's wholly inappropriate for that to occur. And if you comply with that, as you refer to Dan, you can't unring the bell. You've made a mistake. So do something, take your time, get your sites clean, make sure you know where you're going to go with what you're doing.
Yeah, I think that's another great point, Jeff. You should never take legal advice from your client's attorney or from the opposing attorney. And unfortunately, we do get calls about that. I do want to just mention before we take the next question, I know sometimes when we talk about a treating clinician quashing a subpoena or getting a protective order, that tends to increase anxiety. So if you're someone who isn't quite sure what that would look like, or if that stresses you out, that's the point to consult, because there's lots of it may or may not be appropriate for your situation. And that's exactly what both David and Jeff are talking about, where you want to get more information. If that's outside of your bailiwick, so to speak, to use an old term, then you don't want to be attempting to do that until you get more information. Okay, so another question or statement here. In my area, the subpoena is often signed by the clerk court, not by the judge. This makes it difficult to know who is asking for the record or presence of a psychologist. So I guess either of you, David, you want to try this to start?
Sure.
Okay.
That is, if it's not signed by a judge, it's not a court order. The clerk of the court cannot make a subpoena into a court order. And the only thing that you don't have any options are, well, you do have an option if you want to be held in contempt of court, but with the subpoena, you have a number of options that we've talked about. And even if it's the signature of the clerk of the court, it's not the same as a court order.
Yeah, I think, Lisa, you agree with this, a common problem that we get. People say, I've received a subpoena, it's not signed by a judge. Well, subpoenas usually aren't signed by judges.
Exactly.
So,
right.
Court orders are signed by judges and they compel. Court order compels. A subpoena is something that comes from a representative of the court, like a lawyer, usually lawyers, and it's a part of a privilege of discovery in a proceeding. And so these are entirely different things. So if you get a subpoena from an attorney, it's a subpoena and you have to deal with it as a subpoena. You can't go like, well, it's from an attorney and it's not from the judge, so therefore I'm not going to do anything. We told you that's wrong from the get-go. You need to do something about that, and attorneys have a right to issue subpoenas.
Mm-hmm. Right. Yeah, thank you to both of you for clarifying that. Here's another topic. We've already sort of mentioned this, but I think it's worth clarifying because these kinds of questions do come up a lot. So when the treating clinician discusses a patient's diagnosis, I think this is like in testimony. So they discuss the patient's diagnosis beyond just the facts of therapy. Isn't that an expert statement, even though it does not directly address the particular legal issue at hand, although it may contribute to the understanding of the legal issue? So can you talk about here, and David, I'll let you start on this and
Sure.
pick up, but talk about how, is that an opinion or is that a fact of the treatment?
It is still a fact of the treatment. You can conceptualize it as you're being an expert on the diagnosis and an expert on the treatment. You are not an expert on the legal or the forensic issues involved. And people see it different ways. Some people just say, no, you are just a fact witness. Some people conceptualize it as you're an expert on the diagnosis and treatment, but not on the forensic issues. But no, that's not really giving a forensic opinion.
Right, great, thank you, Jeff. I'm sorry, David, anything, Jeff, you want to add there?
Yeah, I think it depends upon state statute, but there are some states that recognize in the law a thing called a treating expert. And it sounds like it's an expert, but it's not. It's actually a category of recipient witness. And it basically says that you come to the court as a psychologist. You're not just the run-of-the-mill witness. You have this skill set that you bring to the court, and the court will recognize your ability to say things like a diagnosis, right? I mean, that's an opinion, and really opinions are for experts. So the courts will allow you to do that, but you need to be protective of that role as well. So my diagnosis was post-traumatic stress disorder, but that was a clinical diagnosis. I didn't do a forensic evaluation. Mm-hmm. Yes, she or he got better. That's an opinion. The court will allow you to render that opinion. There were bumps in the road. There were times that they got depressed. All that's opinion. The court will allow you as a psychologist to do that, but you have to be very careful of not wandering off into the other job, which is, as we've alluded to already, the car accident caused the post-traumatic stress disorder, or they're going to need significant therapy for the rest of their lives because of the trauma that occurred. Those are clear forensic opinions way beyond what you have done as a treating clinician, and you get yourself in trouble if you do that.
Yeah, and let me just add to what Jeff just said, what I called the trick question. They will take what you have stated as a factual matter and then pose you a hypothetical. Would it then be based on your clinical data? Would it be a fair statement that? And they're addressing the legal issue, and that you cannot and should not answer.
Right. Yeah, I think one helpful way to think about this is you can testify as a treating clinician to the facts of your treatment. And as you both pointed out, what you gave as a diagnosis is a fact of your treatment. You are treating this person for depression or anxiety. And as we mentioned earlier, you can give the clinical basis on which you make that determination, right? But you're not saying, as you pointed out, this depression came from the motor vehicle accident or that kind of thing. You're just saying it is a fact of my treatment that I gave a clinical diagnosis of PTSD or major depressive disorder or whatever it is. So sometimes that's a useful way, I think, to think of it.
Yeah, I want to point out, Lisa, look, Jana just posted the link to the
Yes.
Schumann and Greenberg article. Everyone should read that article. That's one of the most cited articles published by professional psychology research and practice. It really defines all this very carefully for the reader. A great link to a great article.
Yes, I agree. And it's super good at explaining those differences and why there is a conflict. And we actually had a question. So thanks, Jana, for popping that in because they were looking for that particular resource. Okay, so another question. If one evaluates a patient as an expert witness and the attorney enlisting your service decides not to use your findings, can the opposing counsel call you as a fact witness? Jeff, you want to start with that?
Yeah. Well, first thing is, if you don't know what to do, don't do anything there, right? Because the fact of the matter is that communication with the first lawyer and the evaluation is under that privilege to that lawyer. So you're being put into a serious conflict of interest. And the other side of, you do an evaluation and you go like, well, yeah, your client is a psychopath and he has no conscience and he really over-sexualizes relationships with women and it's a sex assault case. And the lawyer goes like, we're not using you, you're not helping us at all. Well, the other side can't come in and get that, and the answer to a lawyer that tried to do that is no, the only way you're going to get that information is if you can get a court order compelling me to do it. And he'll never get it because it's privileged under other attorneys' privilege. So that's a great question.
It is a great question.
Yeah.
And just to clarify, this is when you are hired as an expert witness by the attorney to do an evaluation by the attorney. This is not what we've been talking about before, where it's the treating clinician just doing the work, getting called in to testify. So that's why it's different in this case. David, did you want to add something?
Yeah, I just wanted to add one thing, which is there are some states where, the lawyer might say, well, we don't want to use you. And they go ahead and get another expert that they intend to use. And in those states, at that point, when they decide to use someone else rather than you, the state can then try to find out what your opinion was. But it's a limited number of states.
Yeah, and I think it's really important to point out to the people listening here that needs to be defined. That's a legal opinion, and you're not going to do anything until you get a legal opinion about
Absolutely.
whether you have the right to do that. So we go back to that answer to whoever wants this information. The answer is no, you can't have it. You need to compel me to give this information.
Right.
And I think Lisa was pointing out, we're now talking about the role of a forensic psychologist in a matter, which is a little bit beyond the scope. It's a great question, but it's a little bit beyond the scope. What we're trying to do is to protect clinicians or talk about what clinicians should do when they're confronted with a legal system. My experience is that most forensic psychologists kind of know these rules pretty well.
Mm-hmm. Right. Well, because your average, most clinicians that get well trained in clinical work aren't trained in forensics, right? That's part of what Greenberg and Schumann article was about. That if we're just trained in a clinical program, we very likely didn't get anyone teaching us and telling us about these kinds of forensic issues, right? So I think that's important to remember. I also just want to say, one of the main, because I'm worried it might get a little confusing here to folks, but one of the main risk management take homes that we are saying and have said and will say is, again, if you're in a situation and you're not sure what it all means, consult. Sometimes too, if you're new to this, if you're a new clinician, say, and you get your first subpoena, you may not know what you don't know. So in that situation, if this is your first subpoena, you may want to consult even if you think you know, because some of these things are complex and they can get tricky. And there are risks to you and your client if you release something that you shouldn't. So I think that's one of the key take homes. Okay, so here's another scenario. And this is back to the subpoena for records. So again, a little bit, we've talked on this, but let's sort of nail this clarification here. The confusing part is getting a subpoena for records, but there is no signed authorization from your patient. You don't know if it is their attorney or the opposing attorney that has subpoenaed you. I have been told there's a difference between it coming directly from the court versus an attorney as the named recipient. Can you get in trouble by not replying to a subpoena, no matter who is issuing it, if there is no patient signature for release? So the short answer is yes, you can get in trouble for not responding. But David, do you want to jump in on that? And then Jeff will add you in.
Well, again, we're talking about the consultation. It's a tricky situation. You can get in trouble, but if you get that subpoena, you don't know where it's from. You could do the motion to quash, as we talked about before, or you try to find out more about the situation. You will want to talk to the client, and ask them, is it your lawyer who is issuing this? And if not, and do you authorize? Have you authorized this? Show me a copy of the authorization. If it's coming from some other place and you don't know, say there's no issue of their putting their mental state into litigation, then you don't do anything. But of course, you would seek legal consultation as to how to phrase your response.
Yeah, legal or risk management consultation.
Right,
Jeff,
or risk management.
Yeah, do you want to add anything there?
No, I mean, it is very important. Just remember, you have to do something with the subpoena, even if it's wrong. I mean, the subpoena is a living legal document. If you don't have an authorization, you have to take action to protect the interests of the client, but you have to do that officially. Not reacting to it at all just is not acceptable. The easy answer is you have to do something. And we've talked about this already, but don't get this judge lawyer thing confused. If it comes from a judge, it's a court order. It compels, right? And the nice thing about these documents is they say what they are. You are hereby ordered to. Well, that's pretty clear. That's not a discovery question. That's an order from a judge. Then don't get it overly complicated. I mean, actually, this is part of practice. It will happen over and over to all of you in the years that you practice, and you don't need to live in fear of it. It's just something that you need to manage.
Yeah, and I will say, though, I have seen subpoenas that say on a subpoena, not a court order, it says you are hereby ordered to. So sometimes it can be confusing, but yeah, absolutely consult. I think one way that sometimes can be helpful to think about this, you can never not respond to a subpoena. So you should never simply ignore a subpoena, period, regardless of who it's signed by. A subpoena compels a response. It does not compel the release of privileged information. So that's the distinction. So the subpoena means you have to do something. The question is, what are you going to do? And that's where you want to consult before you decide what to do. So you can't ignore it, but you got to figure out the action step before you do that. I also want to say, if you're looking for more resources on this kind of thing, I think we have a whole webinar on how to respond to subpoenas and depositions. So, take advantage of this stuff on our website as well, and those other webinars that go into more detail on that. Okay, so here's another question. What happens if the attorney presses you to give a response about a psychological issue you have treated the patient on? And we've sort of mentioned this, but again, hammer home the answer of, what if I'm the treating clinician and I'm on the stand and they say, well, what about custody, Dr. Bryan? Or what about parental fitness? What should be the response, David?
Very simply, I don't have an opinion on that.
Beautiful, right. Okay, what if I expressed an opinion about causes of memory issues in a neuropsychological report? Can the attorney ask me under oath why I came to my opinion in that report? Jeff?
The answer is yes. If your job is simply to be an assessor of a neuropsychological issue, and that you would say nothing different to the court than you would to anybody else that you prepared this report for, then you're allowed to say that because you're fulfilling the job as an assessor. Neuropsychologists are not advocates for their patients. They're individuals who engage in assessment. I think it would be important to point out that you were not retained to do a legal opinion, that this was a clinical neuropsychological evaluation. But I think that opinion is allowed because I'd be interested in what you all say, because this is what I've taught. So if you don't have anything different to say in the clinical world than you do in the legal world, then that opinion is okay. But if it isn't, then you need to make sure people understand that this was done clinically, which you would do anyway.
Yeah.
Yeah, I definitely agree with that. I think the only thing I'd add there is just ensuring in that instance that you, again, talk about any particular limits of data that you might have. So you may need to say, again, as you point out, Jeff, this was a clinical assessment. I didn't do malingering or if you didn't, like whatever it is that you maybe didn't do that would be done in a forensic eval, you should point that out so that it's really clear what limits there might be for your assessment. But I absolutely agree in that instant, because that, if you think about it, right, that's a fact of your clinical assessment. And so you can answer facts of your assessment. So okay, this is a great question because it comes up a lot. So regarding having an opinion if my patient is fit as a parent. So this is, again, treating clinician, treating a patient, having an opinion if my patient is fit as a parent. What if, based on my clinical work with my patient, I feel that in fact she is a fit parent, but I've not done a formal evaluation? And maybe to complicate it more, I've already stated in a report that I feel her children would be safe with her. How would we handle, there's no exact question here, but let's add the question that that's the case, and now say this clinician is being asked to testify to that in court. What are some of the issues here, and how would you recommend this clinician respond? David, do you want to start there?
Yeah, well, first, I would wonder why these opinions were being reached already. And did they say that they had already put something in writing to that effect? Mm-hmm. Yeah, as a risk management strategy, which you're bringing up, Lisa, that can so easily become bound for court. I think it's ill-advised to put anything like that in a report. You could be almost sure that would come up in court, and then the person would be in the awkward position of doing exactly what we're saying all along, which is you do not give those kinds of opinions based on your work as a treating individual. And then, of course, well, then why did you write this letter? So the best idea is to avoid doing those things in the first place.
Mm-hmm. Yeah, I agree. Jeff, addition?
Yeah, really, this is very important. What does writing that letter have to do with therapy? I mean, you're creating a forensic document. You shouldn't be writing that letter. And the second question would be, based on what opinion? What you're an advocate for your patient. You have research has shown over and over and over, you have an inherent bias because of the nature of your relationship, and you're rendering a forensic opinion. You shouldn't be writing that letter at all. Your records are discoverable. Whatever you've said in the context of that. But asking you if you have an opinion about whether your client or patient is an individual who is a good parent or whatever, the answer should be, I don't have an opinion about that, because you haven't done the job. You created that document. It's already a problem if you write that letter. You should not write that letter.
Yeah, I agree. And I think sometimes it's tricky for a clinician who's been working, say, with a parent, in this case, the mother, for a long time. As a treating clinician, you may feel like you have really important, relevant data to that question, but that's different than actually having done an assessment, right? So I think too, there's an issue of competence that comes in, because keep in mind, there's a different standard of care. There's different methodologies and procedures that go along with doing a forensic evaluation than with doing clinical treatment. And so you don't want to be out on a limb offering a forensic opinion based only on clinical treatment. And I think it's sometimes hard to remember that when we're treating a patient, we may feel like we know all the data, but we don't necessarily, right? It feels like we're in it. We know exactly what the case is, but we don't have the other side. We don't have the father side or the child side or all sorts of stuff that's really important. You know, forensic evals are multi-method and multi-sourced. We don't have that.
My experience with this, Lisa, has been that many of the people who have write those letters have never seen their client even with their child.
Right.
So it's right off the bat, you haven't assessed their relationship with their child or anything that has to do with parenting. You've only taken the word of one individual. So this is really dangerous turf to wander out into.
Yes, I agree. And it's a really good way to get a board complaint by the other parent who says,
Absolutely.
wait a minute, how can you be saying that? So it's very risky to do. Jana, I see you coming on. It feels early. I feel like we've just barely gotten into this, but
Exactly.
I guess
We
we're
could talk for hours.
Yeah,
Yes,
this was great.
yes.
Thank you both, Jeff and David. This was great. I'm sorry we didn't get to more questions.